All right, so today we are on Case Text, and this is a website that you can pretty much do free research online without having to pay LexisNexis or any of the other premium services. Again, caution when using this website and other free websites because this is not a full research spectrum, and sometimes it could be very limited in the search, but it has enough information most of the time if you know what you're doing. Okay, so today we're going to be exploring the foreclosure defense of failure to produce the original note. Now, please pay close attention to what I put here, right? Failure to produce the original note is not the same as failure to produce the note. And the reason I say original note is because banks typically have a copy of the note, okay? You don't want a modified copy. You want assurance that they have the original. And let's get into some detail on why we want the original and how it affects the claim of the bank that may choose to go after you adversely. Okay, so here is the typical home purchasing scenario. You know, a couple or a single man or woman is thinking about purchasing a home. So they now approach the bank, and the bank tells them to submit an application for the mortgage loan, right? And again, a mortgage loan is kind of like not a proper term to really use. It's either a mortgage or it's a loan, right? But in this case, because of the usury that is introduced by this type of loan, it's called a mortgage, right? Very high interest over time. Anyways, you submit an application to the bank, and the bank now, let's actually move this. Hold on. All right, so this is a better depiction of the process. So you submit the application to the bank. The bank, does their checks, does their underwriting, does a lot of things in the background and tells you it's going to take 30 to 45 days to close, right? You don't know what's going on behind these doors. But anyways, the day of closing is the day where the transfer of the property, the assets, the funds, and all these other things happen, right? And you go to a closing agent. The closing agent gives you a bunch of documents to sign. And of course, you don't have time to go over all these documents, to sit there and try to read and ingest and understand everything that's going on. So of course, you sign all these documents, right? And in these documents is something called a note. It's not going to say promissory note. So if you're looking for what exactly is in your document package, if you kept it, it's going to say note at the top, right? And they intentionally do this because they don't want you to identify the thing as a promissory note. But anyways, one of these documents is a promissory note, and this document package with your signature goes back to the bank. Okay. Now, here's what's also happening. Once the bank gets your promissory note, right, within a week, they're stamping it like this. This is actually from one of my documents, from my note. This is one of two stamps that are on there, right? So they've already gotten paid from the promissory note. I'm not going to go into the process of what exactly occurs for them to get paid, but just know that if you request a copy of your note from the bank and it has this stamp on there, the note is no longer original. This right here is a modified note. This is a modified copy of the note. It's not the original. the original does not have a stamp on it or any modifications of the original. Okay? And this is one of the reasons why you need to keep a copy of all of your original documents. Do not ever, ever, ever throw away your loan documents, because they definitely come in handy one day. And I'll get into that in just a second. Okay, so now that we've reviewed the process, we're back here over at case text. And again, if you search properly, right, you have to search, actually. So we're back over here at case text. And like I was saying before, if you search properly, you will find what you need from just this free search engine over here for legal cases, right? It doesn't give you everything, okay? You don't get to see what was submitted by either side. All you see is what was adjudicated in the court and what's in the court record, the public record side. The private documents that are submitted into the case, you would not be able to see that. But I wanted to show you how you can use this website to gain leverage, right? If you're, planning to contest a foreclosure, or, you can't afford your mortgage anymore and you don't want to screw up your credit and all that stuff, this might shed some light on your situation, okay? So here we have, of course, a bunch of cases, and I put this in quote because I want the exact wording in any cases that, have been adjudicated in the past. And also, you can specify by state over here or by federal, or however way you want to gain your sources of information. And I would suggest you narrow it down to your state first, right? You narrow it down to the state, and then if you can't find what you want, then you go federal or national or Supreme Court or whatever, right? All right, so let's take a look at a couple of cases. All right, so here we have a case, Spencer versus Deutsche Bank, right? Sometimes I speak to people and they are so ready to rush into trying to defend something. And they don't realize that oftentimes you can stay out of court and still win. You don't have to go to court. There are strategies that you can use to stay out of court, because court is filled with procedural traps that if you don't follow proper procedure, you might just lose your case on those technicalities, okay? So I would not recommend any lay person just walking up in a court trying to defend anything. Try doing it by mail first. Or, if you have a phone that you can use to record, or a recording device, put them on speaker every time they called, record the conversations, and then transcribe, from it what you need. But don't be quick to run into court, because a whole lot of times, these cases are dismissed based on technicality. And I'm going to show you an example here. So in this case, Spencer versus Deutsche Bank, right? This is like almost close to the end, right? Let's go to the order first. It says, therefore, it is hereby ordered that Northwest's motion to dismiss the plaintiff's case is granted. And here's why. Here's the bulk of the reason. In this case, the court has read the Spencer's complaint liberally and concludes that they are asserting causes of action for a wrongful foreclosure and for failure to produce the original note. First, there is no cause of action for wrongful foreclosure, when no foreclosure has in fact occurred. See what I'm talking about? Jumping the gun. And the court obviously cites cases and authorities they're using to make that determination. A foreclosure of the property has not yet occurred, or has not occurred yet. Therefore, the court grants Northwest's motion and the Spencer's claim for wrongful foreclosure is dismissed. Now, this right here is significant, because when the bank does decide to foreclose, they can now refer back to this case as res judicata, or it was already decided that this party here doesn't even know what their cause of action should be, what a cause of action is. And now that the foreclosure is in play, right, this case that was dismissed already is now going to be related to the foreclosure. So you can't come back and try to defend the thing the same way. This was already ruled on, right? You might be able to find another avenue, but you have to be careful. You can't, like, this person's trying to defend a foreclosure when there was no case in court yet. That's why they were the plaintiff. They don't waste their money to file this case, and the foreclosure didn't happen. Okay? So be very careful. That's one example. And also, here's another interesting part. It says, second, courts have routinely held that a defendant's so-called show me the note argument lacks merit. And it cites another authority they're using, right? The Spencers request that the foreclosure proceeding be halted until they are presented with the original note is a meritless show me the note argument. Therefore, the court grants Northwest's motion to dismiss the Spencers' original note cause of action. So people are going to read this and they're going to go, well, can I still use show me the note defense? Can I still use show me the note offense? Okay, show me the note is not a cause of action. When you go to court, court is for damages. Okay, court is for a violation. Court is for restoring someone to being whole again. So, if you go to court and you can't show how you were prejudiced or damaged, how someone caused something to happen to you, or because of what someone did, something else happened to you, if you can't show that, you don't have what's called a cause of action. You don't have a claim. And, you know, it's hard to swallow for a lot of people. It's like, okay, well, how am I going to show that I was damaged? How am I going to... You have to think about these things before you jump into court. Okay? So if you're going to make a claim, Google it. Google your claim. Right? As a matter of fact, let's look at a couple of examples before we continue. Alright, so here we got Google, right? And as you can see, my search terms were valid claims for damages in Georgia District Court. And here we have an AI overview, which is generally correct. It says to make a valid claim for damages in Georgia District Court, a statement of claim should include plaintiff's name, information, defendant's name and address, the amount of money or property the plaintiff is seeking, right? So you got to know exactly how much you're there for. A brief explanation of why the defendant is being sued, including the dates of incidents. Okay, so this means you should have accurate records, copies of relevant documents such as contracts, receipts, canceled checks, etc. Right? In property damage claims, the extent of the damage should be described and supported by an affidavit from the person whom appraised the damage or made the repairs. Right? Again, this is from, if you have something where you got something that, a claim that could be verified by a third party. There are two types of compensatory damages. Economic and special damages, and non-economic or general damages. General damages are presumed to flow from a tortious act, a tort claim, and can be recovered without proof of an amount. Special damages are those that actually flow from a tortious act, and must be proven to be recovered. So special damages would include something that you can invoice for, right? Something that you can show actual damages that was recorded on some form of record. If you don't have that, it would be a general tortious act, which can be recovered without proof of an amount. So you have to look up, the cause of action that you're trying to recover from. And that way it gives the court a better idea of how they can help you. Alright, so example, if you bring a cause of action for defamation, right? Here are the elements of defamation. And again, these are just, examples of what you can search for. elements of defamation are all right, let's go through this one. So for defamation, you would need to prove that a false statement was made by the party who you claim defamed you, right? Or caused public embarrassment. Publication. The statement must be communicated to a third party. Fault. Defendant must be at fault for making the false statement, at least to the level of negligence. Damages. The plaintiff must show that they suffered harm to their reputation, business, profession, or occupation as a result. Okay? So, if you're going to make a claim, don't think that you could just walk up in a court and explain your situation. It has to meet all of these requirements in order for you to successfully claim defamation, right? And we can look up fraud as well. Right? Click on that. And so let's say you're looking to claim fraud, right? Here are the elements of fraud. All right? So you don't really have to look very far to find out how you can make a claim based on fraudulent misrepresentation or fraud, right? And again, here are also some elements of fraud. And again, this is different sources around the web. So it also depends on what court you're filing in. Because even though you have all these elements, you have to make sure that that is the requirement for that court, right? And you also have constructive fraud. Let's just use in Georgia. Right? And constructive fraud is less restrictive. So that means that you don't have to prove all the evidence, the elements of the original, of the blanket fraud statement, right? However, this one is more blanket, right? Constructive fraud is defined as any act or omission that is contrary to a legal or equitable duty, trust, or confidence, and that injures another. Constructive fraud can be consistent with innocence, while actual fraud implies moral guilt. So, like I said, you have to know what you're doing before you go into court. Don't think just your goodwill and your good faith and your good explanations are gonna get you a win. It's very rare that that happens. Oftentimes, the judge, especially if you're representing yourself, if you're representing your own person, the court is going to look down on you, especially if you're not following the procedures from the get-go. So be very cautious and be very aware of these things. All right, let's get back to the court cases, right? So here's another case, Shavaria versus Fleetwood Retail Corp. And if we go down here, right, we can see the conclusion is the judgment and orders of the trial court are affirmed in part and reversed in part, and the case is remanded for further proceedings in accordance with our opinion. It is so ordered, right? It says, nonetheless, this is the last section of what the judges had to say. Nonetheless, because we reversed the reward of certain damages under UPA, as discussed above, we remand to the trial court with instructions to redetermine the amount of attorney fees to be awarded to plaintiffs without counting any time or work required of counsel on the unsuccessful portions of the UPA claim. Right? The parties have apparently stipulated that remand is appropriate in such an event. Finally, in light of our reversal in part of the UPA claims, we deny plaintiffs' requests for appellate attorney fees. This means that this is an appellate case. This person is appealing from a judgment, and they lost. And let's take a look at why they lost, right? And we're going to go to section 37 here, or paragraph 37. It says, plaintiffs do not respond directly to defendant's claim of waiver, but argue only that defendant failed to meet its evidentiary burden under the Uniform Commercial Code However, in a collection action, the failure to produce the original note or instrument may be waived or excused by stipulation or admission of the parties. In this case, plaintiffs admitted in their answer to the counterclaim that they signed the note. They admitted that the note was assigned to defendant and that defendant was the current owner of the note. The pretrial order does not indicate that plaintiffs challenge defendant's status as the owner or holder of the note. So what exactly is this saying? It's saying that the plaintiffs, Shavaria, simply talked too much. They admitted too much. They did not know what they were doing. In any court case, okay, you never answer about another person or corporation. Never ever. Okay, that is to your detriment if you're asked. For example, it's saying, in this case, the plaintiffs, Shavaria, admitted in their answer to the counterclaim that they signed the note. Okay? Now, how are you going to say you signed the note and you don't have the original? What you should say is, you would like to see the note to ensure that it is your signature that is on there. You can't admit to something that is not in front of you. It's out of your view. And especially if it reaches this stage, usually it's several years down the line, right? So you do not remember all the things that happened at closing, right? You don't even know what the note is half the time. You probably haven't seen the daggone note since you signed it. And chances of you remembering what was on that note is nil. Okay? They admitted that the note was assigned to defendant. They admitted that the note was assigned to Fleetwood Retail Corp. How are you going to know that? If you have not seen those assignment documents or the chain of title, basically the authority from the original holder of the note, passing it on to another corporation or person, how do you know that the assignment was done and the assignment was proper, maintaining chain of title? How do you know that? Okay. And the defendant was the current owner of the note. So this is all admissions. Okay? This is how they hurt their own case. Stop talking. Stop thinking you know anything. Okay? You are in court because you're trying to find out. You're trying to see what the truth is. And the judge is the only person in the court that can determine what is the truth and what are the facts. Okay. The pretrial order does not indicate that plaintiffs challenge defendant's status as the owner or holder of the note. Another mistake. Huge mistake. That should be your primary focus. Okay? Challenge the ownership and the holder status of the original note. So, as you can see here, you have to be very careful, again, with what you say and what you admit to. Oftentimes, again, if you are asked about anything that you are not sure about, if you're not 100% sure, do not answer that question. Let the court know that you do not have personal knowledge regarding that matter. Unless you can verify it for yourself right now, there's no way you will know. So do not put your foot in your mouth. So here's another case. Leong versus JP Morgan Chase. In the discussion, it says, plaintiff's complaint fails to satisfy the standards articulated in Rule 8, Rule 12b-6, and Iqbal and Twombly, and in Iqbal and Twombly. However, in the interest of justice and because plaintiff is representing herself pro se, the court will grant plaintiff leave to amend her complaint So the court is giving this plaintiff a chance to go read up on these rules and also these two cases. Or it looks like this case right here. Okay? So it says, in their motion, defendants... Okay, so it's giving the pro se. Okay. So in their motion, defendants point out that plaintiff's complaint appears to allege a claim for a violation of Regulation Z, Federal Truth in Lending Act, TILA, codified 15 U.S.C. 1601, for failure to produce the original note. Defendants also correctly point out that defendant's complaint fails to cite any authority that requires defendants to produce the note. Very important here. Okay? When you have a court case, especially if your case reaches to the federal level or the district court level, you want to make sure you cite authorities. Authorities includes legal dictionaries like Black's Laws or Bouvier's Law Dictionary. It includes other court cases that support what you're saying. It includes any kind of laws, rules, or regulations. And it also includes court opinions, right? Opinions from judges regarding that subject matter that you're trying to pursue. If you do not include any of these authorities, you're going to lose. Just straight up. You're going to lose because it requires some kind of authority in order for you to prevail on your claim. It could also be the Bible. As strange as it sounds, if you are good with articulating what's in the Bible and relating it to real life situations, you can prevail using the examples and the citations from the actual Holy Bible. Okay? So, that being said, don't walk up in court filing documents and doing the most and think that just because your case sounds good and it has a whole bunch of facts in it that you're going to prevail. That's not how it works. You have to use a previous authority that was successful in the claims that you're making. So, and this is why I tell people all the time, go look or go search for previous cases that support what you're saying. You're not an island. You're not a mountain. You have to lean on the authority of what was done in the past. If you don't do that, chances are you are going to fail. Okay? So, for this case, in the conclusion, it says, it is hereby ordered that the motion to dismiss is granted. So, JP Morgan Chase got their motion to dismiss. It is further ordered that plaintiff is given leave to amend her complaint consistent with this order within 21 days after this order is filed. Okay, this is generous. Okay, the judge and the court is saying the case is not completely over yet. They're giving this individual a chance to go fix their issues that is outlined in this conclusion, this order, right? Go look through, go do your research, file a proper claim, and come back and let's see if we can get you a favorable result. And that's what the courts usually try to do. They try to get you, they try to make the plaintiff whole by having substantiated claims. They don't really just dismiss your claim just like that and don't give you an option to fix your problems. If you come in there trying to act like you're the big bull, then sometimes they'll dismiss your case with prejudice because they're saying that you're basically coming in there belligerent. You're coming in there as an adversary, not as a friend of the court. And that's why, again, your demeanor is also considered when the judges are looking through these cases. As you can see, this is, again, United States District Judge. So this is District Court that this case is in. Ladies and gentlemen, when you go to court, if you have to go to court, Be very careful. Okay? Don't go in there cocky. And of course, we're all going to be, uneasy going to court, right? Especially if you don't know how to conduct yourself. A lot of people say, get an attorney, get an attorney. That does not matter in this day and age. Unless you have an attorney that can prove that he or she has won cases like yours, then that's out the window. Don't think just because you have an attorney, you're going to be successful. Okay? If you have an attorney, oftentimes you have to tell the attorney what you're looking for. How do you believe that you have a claim? You shouldn't just tell the attorney, well, the bank is trying to foreclose on me, and I know that they're defrauding me and this and that and whatever. Unless you have concrete evidence, you don't know that the court is that the bank is doing anything. You don't know. You probably hear something online. You probably seen some documents. You probably seen screenshots or whatever, and you figure, hey, you know what? I'd rather stand up than sit down, right? So you need more concrete footing to stand up against the bank. You have to know how to approach the situation. And in the next video, I'm going to go over some strategies that you can use to avail yourself of the embarrassment and also sound more intelligent, right? Whatever claims you're making, you want to make sure that you're able to substantiate your claims. You're able to show that you're not the one that's saying anything. It's the person making a claim, or it's the company making a claim. That is who should be put to show their cause of action. And a lot of times it's better if you wait until the bank decides, if they decide to go to court. Because for one, they have to bear the cost, right? They have to bear the cost of the action if it's a state where they have to go to court to adjudicate the foreclosure, right? If it's a state where it's a non-judicial foreclosure state, you want to file the claim first, because either way, if you want to defend against that, then you have to be the one to initiate a claim. So, but it has to be timed right. So in the time that you decide that you're going to do this, you have to start studying. You're going to have to start researching, making notes, putting together all your documents and all of your points that you're going to be making. And also, before any of that happens, you should be confronting the bank. You should be making billing error requests or demands. You should be doing a lot of things before that time comes around. So if and when that does come down to the platter, you have evidence to show what you've been doing, how you've been, trying to be amicable with the bank to make sure that they're in the proper authority to do whatever they're doing. And oftentimes they will fail those tests. They will fail. So again, court starts in the mail. So don't ever try to just use court as your first resort, because the judges can also tell when you haven't done your due diligence and you're coming into court thinking that, hey, you know what, I have a better chance in court than I have outside. And sometimes it's worse. As hard as it is to swallow, sometimes those assumptions turn out to be worse. Okay? So again, that's it for this video. I just wanted to show you some of these court cases that are unsuccessful and why they're unsuccessful, and also how the judges help you out in a lot of cases. So I'll see you in the next video. Hope you all have a great day, and I will put together more detail in the next video to come.